The Supreme Court ruled on Monday that former President Donald J. Trump is entitled to some level of immunity from prosecution, a decision that may effectively delay the trial of the case against him on charges of plotting to subvert the 2020 election. The vote was 6-3, dividing along partisan lines. Chief Justice John G. Roberts, Jr., writing for the majority, said Mr. Trump had immunity for his official acts. The president is not above the law, the Chief Justice wrote. But Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch under the Constitution. And the system of separated powers designed by the framers has always demanded an energetic, independent executive. The president therefore may not be prosecuted for exercising his core constitutional powers, and he is entitled, at a minimum, to a presumptive immunity from prosecution for all his official acts. In dissent, Justice Sonia Sotomayor wrote that the decision was gravely misguided. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency, she wrote. It makes a mockery of the principle, foundational to our Constitution and system of government, that no man is above the law. The justices said there was a crucial distinction between official and private conduct and returned the case to the lower courts for additional analysis. It was not immediately clear how much delay that would entail, but the prospects for a trial before the election seem increasingly remote. If Mr. Trump prevails at the polls, he could order the Justice Department to drop the charges. Mr. Trump contended that he is entitled to absolute immunity from the charges, relying on a broad understanding of the separation of powers and a 1980 Supreme Court precedent that recognized such immunity in civil cases for actions taken by presidents within the outer perimeter of their official responsibilities. Lower courts rejected that claim. Whatever immunities a sitting president may enjoy, Judge Tanya S. Chutkan of the Federal District Court in Washington wrote, the United States has only one chief executive at a time, and that position does not confer a lifelong get-out-of-jail-free pass. A unanimous three-judge panel of the U.S. Court of Appeals for the District of Columbia Circuit agreed. For the purpose of this criminal case, former President Trump has become Citizen Trump with all of the defenses of any other criminal defendant, the panel wrote in an unsigned decision. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. In agreeing to hear the case, the Supreme Court said it would decide this question, whether, and if so to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. The court heard two other cases this term concerning the Jan. 6 attack on the Capitol. In March, the court unanimously rejected an attempt to bar Mr. Trump from the ballot under Section 3 of the 14th Amendment, which made people who engage in insurrection ineligible to hold office. The court, without discussing whether Mr. Trump was covered by the provision, ruled that states may not use it to exclude candidates for the presidency from the ballot. On Friday, the court ruled that federal prosecutors had improperly used an obstruction law to prosecute some members of the pro-Trump mob that stormed the Capitol on Jan. 6, 2021. 2 of the 4 charges against Mr. Trump are based on that law. The court decided the case restoring Mr. Trump to the ballot at a brisk pace, hearing arguments a month after agreeing to hear it and issuing its decision a month after that. Editors picks a visual history of the Harlem Renaissance when the doctor says your disease is just stress. The great air conditioner glow up. The immunity case has moved at a considerably slower pace. In December, in asking the justices to leapfrog the appeals court and hear the case immediately, Jack Smith, the special counsel overseeing the prosecution, wrote that it is of imperative public importance that respondents' claims of immunity be resolved by this court, adding that only this court can definitively resolve them. The justices denied Mr. Smith's petition 11 days after he filed it, in a brief order without noted dissents. After the appeals court ruled against Mr. Trump, he asked the Supreme Court to intervene. 16 days later, on Feb. 28, the court agreed to hear his appeal, scheduling arguments for almost 2 months later, on the last day of the term. Another 2 months have passed since then. At the argument, several of the conservative justices did not seem inclined to examine the details of the charges against Mr. Trump. Instead, they said, the court should issue a ruling that applies to presidential power generally. We're writing a rule for the ages, Justice Neil M. Gorsuch said. I remind you that the Supreme Court's conservative majority appeared ready on Thursday to rule that former presidents have some degree of immunity from criminal prosecution, a move that could further delay the criminal case against former President Donald J. Trump on charges that he plotted to subvert the 2020 election. Such a ruling would most likely send the case back to the trial court, ordering it to draw distinctions between official and private conduct. It would amount to a major statement on the scope of presidential power, though there was seeming consensus among the justices that the case could eventually go forward based on Mr. Trump's private actions. The additional proceedings could make it hard to conduct the trial before the 2024 election. There were only glancing references to the timing of the trial and no particular sense of urgency among the more conservative justices at Thursday's argument. Instead, several of them criticized what they suggested was a political prosecution brought under laws they said were ill-suited to the case at hand. If the court effectively blocks a prompt trial, particularly after it acted quickly in March to restore Mr. Trump to the ballot in Colorado, it will surely ignite furious criticism from liberals and others who view the former president's actions as an assault on democracy and the rule of law. Chief Justice John G. Roberts, Jr., who understands himself to be the custodian of the court's prestige and legitimacy, did not tip his hand very much, though he seemed deeply skeptical of the decision from a unanimous three-judge panel of an appeals court in Washington rejecting Mr. Trump's immunity claim. The appeals court ruled, he said, quoting from its decision, that a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Michael R. Dreeben, a lawyer on the special counsel's team, said the passage was tautological, a term the Chief Justice seized on. Why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not the law? Chief Justice Roberts asked. Such further proceedings would take time, of course. If Mr. Trump prevails in the election, he could order the Justice Department to drop the charges. The argument, which lasted more than 2.5 hours, was largely focused on whether Mr. Trump and other presidents could be prosecuted for their official conduct and on how to tell the difference between those actions and private ones. D. John Sauer, M.R., Trump's lawyer, argued for an expansive understanding. In answer to hypothetical questions, he said that presidential orders to murder political rivals or stage a coup could well be subject to immunity. But several of the conservative justices seemed disinclined to consider those questions or the details of the accusations against Mr. Trump. Instead, they said the court should issue a ruling that applies to presidential power generally. "We're writing a rule for the ages," Justice Neil M. Gorsuch said. Justice Brett M. Kavanaugh also said the court should think about the larger message of its decision. "This case has huge implications for the presidency, for the future of the presidency, for the future of the country," he said, adding, "It's going to cycle back and be used against the current president or the next president." Justice Samuel A. Alito, Jr., in an inversion of the conventional understanding of the Jan. 6, 2021, attack on the Capitol, said that a ruling for Mr. Trump could enhance democratic values. A stable, democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully, he said, adding that the prospect of criminal prosecution would make that less likely. Will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? He asked. And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail. Justice Gorsuch identified what he said was another negative consequence of allowing prosecutions of former presidents. "It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves," he said. Justice Sonia Sotomayor said she had a different understanding. "A stable democratic society," she said, "needs the good faith of its public officials." If there was a member of the court's six-justice conservative majority who seemed ready to send at least a part of the case to trial in the near future, it was Justice Amy Coney Barrett. She elicited concessions from Mr. Sauer that, for instance, Mr. Trump's use of a private attorney who was willing to spread knowingly false claims of election fraud to spearhead his challenges to new election results was private conduct. Mr. Dreeben, the government lawyer, said it was beyond question that parts of the case concerned private conduct. When working with private lawyers and a private public relations advisor to gin up fraudulent slates of electors, Mr. Dreeben said, that is not any part of a president's job. Mr. Trump is accused of a sprawling effort to overturn the outcome of the 2020 election, including by seeking to recruit bogus slates of electors in a bid to alter vote counts and pressuring an array of officials, like Vice President Mike Pence, to subvert the results. Mr. Trump faces a count of conspiring to defraud the government, another of conspiring to disenfranchise voters, and two counts related to corruptly obstructing a congressional proceeding. The case before the court involves just one of 4 sets of pending criminal charges against Mr. Trump, including those at issue in a trial underway in state court in Manhattan over accusations of hush money payments meant to skew the 2016 election. Whatever happens after Thursday's argument, the 2024 election will take place in the shadow of the criminal justice system. Justice Alito proposed a broad principle to distinguish official and unofficial conduct. Suppose, he said, the rule were that a former president cannot be prosecuted for official acts unless no plausible justification could be imagined for what the president did, taking into account history and legal precedent. Justice Sotomayor objected, saying that plausible is little different from absolute. What is plausible about the president insisting and creating a fraudulent slate of electoral candidates? She asked. The 2 lawyers on Thursday faced many questions about which of Mr. Trump's acts were official and which private. They drew different lines, but neither took a categorical position. Justice Kavanaugh said more work needed to be done. The president is subject to prosecution for all personal acts, just like every other American for personal acts, he said. The question is acts taken in an official capacity. Lower courts, he said, should sort out which is which. The court has heard 2 other cases this term concerning the Jan. 6 attack on the Capitol. In March, the court unanimously rejected an attempt to bar Mr. Trump from the ballot under Section 3 of the 14th Amendment, which made people who engage in insurrection ineligible to hold office. The court, without discussing whether Mr. Trump was covered by the provision, ruled that states may not use it to exclude candidates for the presidency from the ballot. Last week, the court heard arguments in a challenge to the use of a federal obstruction law to prosecute members of the mob that stormed the Capitol. 2 of the 4 charges against Mr. Trump are based on the obstruction law. The justice seemed skeptical that the law, which was a reaction to an accounting scandal, applied to the rioters' actions. That skepticism was evident on Thursday, too, with Justice Gorsuch recasting the Jan. 6 assault to illustrate what he suggested was a misuse of the law. Let's say a president leads a mostly peaceful protest sitting in front of Congress because he objects to a piece of legislation that's going through, Justice Gorsuch said, and it, in fact, delays the proceedings in Congress. He added, so a president then could be prosecuted for the conduct I described after he leaves office? His tone suggested that the answer must be no.